Howdy, guys. Attorney Walter Knott. I just wanted to apologize for starting so late. It is currently 8:21 p.m. and we're supposed to be starting at 8 o'clock. Now, with that said, I just want to go through a few basic introductory details, and then we'll actually go into the full section of this where we go into answering questions that people have about Social Security disability law. So, first thing, Attorney Walter Rudolph Knott III, a little bit overworked and tired, work at Social Security Disabilities law firm. Oh, sorry. Wow, really tired. Hold on. Let me redo that a little bit. Attorney Walter Knott. I work at, right here, Disability Resolution PA. And I usually work with, almost every single day, the Social Security Administration, who handles Title II and Title 16 benefits. What are Title II and Title 16 benefits? Really, really easy. Title II is fancy chatter for Social Security Disability Insurance, and then Title 16 benefits are supplemental security income. All right, let's go into this. So I'm an independent attorney that works for Disability Resolution PA. So I own a law firm. And what we're going to be doing today is going through any and all questions that you might have about Social Security disability benefits. We're also going to have some guest speakers until my phone runs out of battery because I didn't get a chance to, charge it. So what we're going to do right now is go ahead and go through some of the basic intros. First thing I want to do is that if you guys are looking for really quality masks that are just incredible, masks that you can wear anywhere, you can wear them to Publix, Walmart, you can wear them to court, whatever you want. Let me see if I have one around here. I don't at the moment. They're called second wave masks, and they're actually made by somebody that does an amazing job. Her name is Cheyenne, and she makes them personally directly for you guys. So you get to pick out your fabric, you get to pick out your shape and all that jazz. So your size, so you can go ahead and do those options. Now, if you see the thingy behind me moving, that is because I have two piggy dogs, and those piggy dogs are literally running around. So if you see that, it's not because there's an earthquake, it's because I have two piggy dogs. All right, so next thing, I want to do a quick introduction to spaceconstitution.com, and then we're going to go straight to the callers. Spaceconstitution.com is an idea that I'm still working on. I've been so busy with things, working on taxes, boats, law firm, hearings, all that jazz. Spaceconstitution.com is a website that I'm currently building that is the first open source constitution. It allows people to go ahead and basically put in ideas that they have that people should have as rights. The right to choose who you're going to have kids with, the right to choose who you're going to marry, the right to A, B, C, D, E, F, G. Better defining what rights come from these massive, rights that we think of, like the right to privacy. Well, what does that really mean? Should we split it up and create more rights based upon it? That way they're solidified? Probably. So I just want to go through, that's a website I'm building. It's the future of things because it will give humans the option to have essentially rights that are not currently utilized or allowed in countries, even including America. A lot of rights were taken away in 2001 and even before then. So just something to think about. Okay, so what we're going to do is, I know some people want to call in. I am super duper tired tonight because I've been working significantly. I do have somebody that I do want to go ahead and call who is a current claimant who got a denial, and I want him to go through his denial situation so we can talk about higher level trial tactics and Social Security disability tactics. So with that said, what I'm going to do is I'm going to go ahead and pull up his name over here. There it is. And we're going to call the gentleman right now. I see you guys are loading. Howdy, guys. See, we have 16 people in there. Howdy, guys. Remember, if you want to call in, it is 407-277-1954. There we go. Now, first call I'm going to be going ahead and doing. Let's see. What advice do you have if my doctors won't give me fictional capacity letters? Functional capacity. Yeah, I wouldn't say fictional. And my psychiatrist won't write me a narrative letter just because they are the types of docs that don't write them. So first thing you're going to do is immediately find new doctors who will go ahead and write them. And most of these doctors will still write them for a fee. They want $60, they want $100, they want $150. So Laura, what you're looking at here is finding a doctor who will write an RFC or residual functional capacity form. You want to specifically have them fill out an RFC if you can that has a lot more detail than just the SSA one. But if all you have is the SSA one, that's okay too. You don't need to have one that's specific to your impairment, but it does help if you do have one. However, the ones you're really looking for are the ones that address the 5 elements of disability law, which are the 5-step sequential process elements. Cool. So Laura, find new doctors, because otherwise they're just going to be problematic. And the moment you start telling them and dictating to them that, hey, I'd really like you to write a letter, they're going to start CYAing their butt with their diagnostic impressions to make sure that they don't get in trouble with their board. Okay, let's go ahead and make a call real quick. Here we go. Sorry, guys. All my tech right now is a little bit sleepy, kind of like me. But we'll see if we can wake it up as we go through this process. Maybe I should have a little bit of sugar or chocolate or something, but either way, no biggie. We'll make it through. Okay. Could put the volume way up for you guys. Let's see what the next question is. Hi, Walter. I'm 36 with all. Howdy, good sir. Attorney Walter Knott. We are live on YouTube. What we're going to be doing is we're going to be going ahead and going through a unique scenario that I think is important for people to understand. Let's go ahead and create a fake name, good sir. What fake name would you like to use?
Josh.
Josh. Excellent. Josh, you recently got a denial. Can you give me the... Oh, wait. Before we go into that, I want to explain to people there's two things that you need to know about this scenario before we go into an analytical study of it. Number one is that there is such a thing as an ME and an MC. An ME is a medical expert. An MC is a medical consultant. An ME, medical expert, is somebody who you go and see, right? So you go to a consultative examination. That's where you go to the SSA's doctor, even though they're not the SSA's doctor, even though they pay for that doctor, even though that doctor mostly or solely sees, those types of claimants. So the bottom line is that what will happen is you will go ahead and go in front of an ME. An ME is a medical expert. However, somebody who reviews your file who does not, I repeat, does not see you is an MC. That's a medical consultant. That's an individual who basically will work with your file and the DDS rep or the ALJ, administrative law judge, to review your record and then give medical opinions related to your file. So with that knowledge, good sir, can you go ahead and give me a fact pattern explaining what happened with your medical appointments, when you went to them, when you got the denial, when the denial was written, and a little bit of the issue of timeline there and what that probably means. Do the best you can, and then I'll jump in.
Oh, sure will. So basically, the Social Security office sent me to one of their doctors. Sent me to was more or less chiropractor. And the chiropractor had me do some tests. In other words, if I could walk, if I could my own range of motion, I believe. And he checked my legs. He asked me to lift some things, like a certain amount of pounds, which I was not able to do. And that was that. I left there, and then about, I would say 2 weeks later, I heard it.
Oh, the phone cut out there. So say it again. What happened?
I got another doctor that the Social Security office wants to send me to.
Okay. Okay, so let's go through this. You were sent to a couple of consultative examinations. You had your own doctors. Tell me,
yes, I do.
You received a denial. What was the date? Yeah, what was the date on the denial letter?
I believe it was September 30th.
Say it again.
September 30th of this year.
Okay, September 30th. Okay, so we got 9/30. And now walk me through this. They were waiting for you to go to some doctor's appointments before they were going to release that decision. What were the dates of those doctor appointments?
All right.
Oh, God. The phone cut out there again. We have kind of a bad connection.
Okay, so the first one was September 22nd.
Okay, September 22nd.
And then the second one was September 25th.
Okay.
And one was a neurologist, another was a pain and rehab doctor.
Okay. Now, for the people watching, were these both SSA doctors or some of them your doctors?
Okay. The neurologist was new, but the pain and rehab doctor I've been seeing over 3 years.
Okay. So we got a mixture of SSA doctors and your doctors, or all your doctors?
It's a mixture of both.
Excellent. Okay, so we've got a mixture we have one doctor on the 22nd. We have one doctor on the 25th. We have basically a decision that was mailed out on the 30th. Now, here's the issue we're going to run into. Can you tell me how many days are in between the 22nd and the 30th, and how many days are in between the 25th and the 30th?
The 20. Well, the 22nd would be about 9 days, and the 25th would probably be about 5. That's including weekends, though. About 5 days.
Okay. So we got 8 days, and we got around 5 days. Then we take the weekend out of it. We're even less. We're looking at anywhere from 3 to 4, and then we're looking at like 6 to 7. Okay, cool. So what's the problem that you foresee with going to the doctors and then immediately receiving a denial directly after that? Do you feel that the DDS rep properly went and obtained the medical documentation from those medical facilities and used it to adjudicate your claim?
No, I did not.
Okay.
I don't believe they got all the information.
Okay. And now, just as an outliner, at the initial filing level, it is the Social Security Administration's duty to go ahead and purchase the medical records of the claimant. So what attorneys do and what everybody does is we go ahead and send to the DDS rep, here's the medical documentation, here's where you go get it, here's when he went, here's what he was seen for, go get it. And they go and buy it. Now, with that said, with only that many days being present between those, can you tell me which was the SSA doctor and which was not the SSA doctor? The 22nd or the 25th for the SSA doctor?
Both of those are my doctors.
Okay, so both were your doctors. So it would be correct to say that she probably did not go ahead and purchase those records because it would take them more than a week just to send them.
Yes, that's correct.
Okay, and if she did that, now let's call it like it is. This lady was waiting to go ahead and have a decision. So, and what I'm going to do is, guys, real quick, and Charles, hang out here. I'm going to go ahead and let Sweetie outside real quick. 1 second. Okay, actually, let me see. Let me see if I can get somebody to go ahead and let her. Would you be so kind as to let Sweetie outside? No. Thank you. Perfect. Okay, so what this means is that the DDS rep basically didn't do her job. Her job was to go and purchase those records from those two doctors. We knew, and she knew specifically, you even talked with her that she was waiting for you to go to these medical positions, yes. Right? Okay, so she knew.
Yes,
yeah, so you tell me, what did she say?
She said she was waiting on the last one from the 22nd, but she acted like she got tired of me calling her.
Mm-hmm. Okay. So basically,
her voice.
Gotcha. So basically what that equates to is she wanted to go ahead and just render a decision. And when DDS reps just want to render a decision, they're going to render one way or the other. But the bottom line is they're going to write it up so that it can be denied. And what they do is they write it up into what's called a DDE, which is disability determination, explanation. And what that has in there are a lot of things. It has your MDI, which are your severe impairments that they're considering as per the elements for listings in element 3. It has a list of the communications that occurred. It has a list of what the doctors were saying. So here's what we're looking at. Do you feel that within those 6 to 7 days, not including the weekends, that she was able to obtain the medical records and then have somebody on the staff review the medical records and give her direction as to how to make a decision and then basically type up and render that decision?
There's no way, not in that amount of time, no.
Right. There's no way. There's no possible way. So what we have here, is a DDS rep who decided that she didn't want to wait anymore. She didn't care. She wanted to make a decision, and that was it. And so what this equates to is an unfair decision. They happen all the time in SSA land, and they're more shocking when you're dealing with the administrative law judges because they have to write out a huge brief explaining why they came to the decision. But now I want you to tell me this. You received the denial letter, correct, in the mail?
Yes.
Okay, and that denial letter, did it go into detail as to what, how she came to her decision with denying you?
Not detail, I don't believe.
Right, so it was a template boilerplate, and on the last page, it may have mentioned some medical facilities, right?
Yes.
Okay, so basically, it didn't have any analysis in it.
No, not at all.
Okay. So if it doesn't require so if the SSA doesn't require for it to have any analysis in it, what does that mean to you?
That they treated me wrong. That wasn't right.
What it would mean to me, yeah. I mean, what it would mean to me is they basically went forward, and she can make a decision left or right very easily, and she doesn't have to really explain it.
Yeah, without having all the medical evidence.
Mm-hmm. Okay. So, do you think that's fair that DDS gets to make a decision without having to really explain it?
No, it's not fair.
Okay. Do you feel that if they had to explain their decision and send some analysis with it, that they would have to go ahead and put a little more effort into the decisions they make at initial filing and reconsideration?
Yes, I do.
Okay. Do you feel that that's an improvement? Yeah. Now, do you feel that's, well, I mean, you tell me, do you feel that that's an improvement that the SSA should make going forward?
Yes.
Okay. And you tell me this, when it comes down to these decisions being made by these DDS reps, are these DDS reps highly educated in the system?
I don't know what her qualifications are, but sure didn't sound like it that she had any qualifications to me.
So the truth of the matter is some of them have a college degree, and basically none of them have high-level academia, to go with it. And that's kind of the sad thing. A lot of people are like, well, at least this person has a master's. No. Nope, they sure don't have to have that. So bottom line is when you guys are worried about, hey, am I going to get a decision at the initial filing level that's fair? I can't prescribe that it will be fair, because you're dealing with highly emotional people that are not highly trained, that do not have a higher level of education like a doctorate or even in most cases a master's.
Yeah. No, it's not fair that I got treated the way I did.
Mm-hmm. Gotcha. All right. Well, good, sir. I'm going to catch you a little bit later. I'm going to call another person, but we'll catch up on Monday and we'll go from there.
Yes, sir. Thank you so much.
Thank you, good sir. I'll catch you later. Bye-bye.
All right. Bye-bye.
Bye-bye. Okay, so here we go, guys, real quick. I want to go through some of the details of some of the future videos we're going to be coming out with. I'm going to put the phone number up there so that people can call in. The doggies just came back in, so they're going to be snarking and barking a little bit in the near future. There's a phone number you can call in if you want, but I want to talk to you about two things: strategy, and then also alternative, videos I'm going to be producing in the future. There's going to be a series of videos that will be produced, and I think it's going to probably be the top 10, but it might slinky into a top 20 on how people receiving disability benefits, and more realistically, receiving their back pay when they win their benefits, can go ahead and get a mortgage. Now, I want to put a quick disclaimer on this. A lot of people that I represent are low income, are homeless, things like that. And basically, because of that, they have a tendency to go ahead and receive their back pay funds and use them on alcohol, tobacco, and narcotics. This is a set of videos for those individuals who, oh God. So this is a set of videos for those individuals who actually want to own property, who actually want to own the place where they live. They actually want to own, going forward, essentially a little place of heaven. And with that said, they can basically tell people to go bleep themselves if they go on their property, which I think is a great thing for disability people, because people who are disabled are usually in a more fragile state, and giving them that power of having that property is excellent. All right, so the thing is, I'm going to create a video, top 10, and it's going to go through basically those types of programs that exist, specifically for disability benefits, those types of programs that exist as a general obtaining a house mortgage program, and then it's going to go through how to utilize your back pay funds the most smart and intelligent way. Okay, so with that said, I now want to go into tactics with the Social Security Administration, what's going on right now. Some of you guys have already received your benefits, which is a major, major thumbs up, which is excellent. Some of you guys are still trying to obtain your benefits, which is totally amazing and totally fine. With that said, when it comes to those trying to obtain benefits, there are certain things going on right now that you can be doing to really boost everything for yourself. Let's talk about that. Due to the coronavirus, we do not know when we're going to be having hearings next. The idea was to go ahead and have them once the coronavirus has kind of worked its way through and we have a better understanding as to how the system's going to go with people being potentially around judges. The reason, obviously, the judges are at home doing all these hearings and doing the quarantining and being ordered to do the quarantining is because most of these judges are older. That's kind of the bottom line deal. The youngest judge I know is in her 40s. And I mean, I was there when she was doing her training under another judge to go ahead and be found disabled. But the youngest judge I know, that's an administrative law judge, is in her 40s. And there's a thing here that you need to know. They're not going to bring these administrative law judges back until way, 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 way down the line. Credit cards for years I'm not working now. Oh, 10 cents in debt. No way I could get a mortgage. Well, okay, so that's actually your credit isn't the main thing that's going to define getting a mortgage. Okay, so here's one of the big things. With back pay, if you have it or you obtain it or you still have it, and yada, yada, or it's coming to you, you can actually use that through some of these credit programs to go ahead and get a place because it's not directly related to how bad your credit is. So I know a lot of people are thinking, if I have disability benefits and I just get in and I get my back pay, it's all going to be about my credit. It's actually not, which is a little bit unique. But think about it. Credit, the way it works is they're really looking at the government's credit to pay you. And if you're found disabled and your disabilities are, those that are going to stay on the disability roll, then you're going to have continuous income. All right, so let's talk about what's going to happen with this whole coronavirus thing. And we're going to be doing a shorter night tonight. So if you guys want to call in earlier. Here's what you need to know. They're probably not going to bring these administrative law judges back for another year. Could be a year and a half. So if you're one of those that's waiting to go ahead and have an in-person hearing, don't. It's not realistic. And here's why. If you want to have a hearing that's in person and you keep putting it off, that's not smart because right now they're processing claims really fast through the initial file. Well, actually, no, initial filing is going really slow right now, but it will kick back up again. It was going fast and then it got slow and now it's going to go fast again in about a month. The bottom line is this. The time that it takes to get through initial filing and reconsideration, you could have the hearing right now, get a denial, refile, go through the process again, potentially get a better judge, and then go ahead and get a better adjudication. Now, if you sit there and wait for more and more back pay, that's not a good way to look at it because if you refile for SSI, you just don't count the first month. For SSDI, you don't count the first 5 months. So the bottom line is you should have your hearing now. Because if you're going to wait that year, potentially a year and a half to 2 years, it would be smarter to go ahead and have your hearing now and then get another shot with another judge if you need to. Okay. 11 months in reconsideration, is that normal? No, but I've had a couple of claimants right now where, all right, so here's the deal. If your claim somehow they do something stupid at the local field office or it's stuck for some place and something's going on, you have to keep calling managers to move it along. And that's the bottom line. If you have, let me give you an example. I had a claim at reconsideration level where basically the person who was supposed to be working the claim, the DDS rep, they got fired. They were no longer there. They were gone. And so the bottom line was the claim was just sitting there and I kept calling into that person. And then like a month and a half later, I was like, that's it. Calling the manager. You want the manager or you want the regional manager? And what you'll do is you'll call the DDS 800. Well, it's not 800, but you'll call the DDS number. It's like an 800 number. And then what you'll do is you'll press the £0. You'll ask to go ahead and speak with the manager for the following, and then you give them the social security number. And the manager for that particular DDS rep will then hopefully answer. And if they don't answer, call back and ask to speak with the manager of that manager because one of them is going to pick up. And then what you do is you ask, okay, what's the holdup? What can I do to push this forward? What's missing from the file, etc. Now, look, here's the deal, Teneki. If you're missing forms and they can't go forward with it, then yeah, that's a reason why they're going to sit with it. And you got to complete those forms. If you're not completing your 3373s, your 3369s, or whatever's, then at that point they're going to want to push it forward. However, if they're just sitting there, right, and they are scheduling physical CEs, they are scheduling mental CEs now. So if they're just sitting there waiting to schedule you for a CE, then there's a problem. But no, 11 months is way too long. Things are screwed up right now. They really are. I have probably about 20 claims where it's like they're stuck on some weird little thing or they're just not pushing forward and having to get the managers to push them. So it's one of those gigs. But I would say this, I think things are getting better. So, sweetie. So basically what that means is 11 months is not right. So Teneki, if you get a chance, what area are you from? and then basically have you already talked with the manager, things like that. Absolutely. Thank you, good sir. Okay, so strategy. So the bottom line is you should do, if you're at the ALJ hearing level, do your hearing, because then if you get Tennessee, okay. And at Tennessee, do you have the DDS phone number for Tennessee? Maybe you do, maybe you don't. But you can go ahead and search it on Google. It's kind of a no biggie, and should be easy to do. Hold on, I'm getting some messages here. Okay, cool. So the bottom line here is, and we may be doing a shorter night. Well, we're definitely going to be doing a shorter night. The bottom line here is do your hearings, because you can go ahead and get a better judge the second application around if you don't want to use appeals counsel. I want to talk about appeals counsel too, because a lot of people tend to abuse appeals counsel as an option. Appeals counsel is only if you have grounds that legally are known, okay, or potentially unknown if it's really good, but legally mostly known to render a popular decision. So what, a favorable decision, a decision that's going to either remand you back to the judge or give you a fully favorable or partially favorable at the appeals counsel by the AAJs. So what do I mean by that? What I mean by that is you only want to go to appeals counsel if you have the grounds to know you have the potential to have a remand or decision right there that's going to be favorable. Otherwise, here's the big thing. Otherwise, you're wasting 12 months. Could be 9 months, could be 15 months, but you're pretty much wasting 12 months. You only want to go to appeals counsel if ... you have the grounds that are likely to go ahead and remand and have a positive decision, and you can wait the time. And what do I mean by waiting the time? Some of you guys have date last insured situations. That's where you'll have a date last insured that's like, basically within the next 6 months. And if you go ahead and go to appeals counsel, you'll be waiting for 12 months. Now, this is tricky stuff, and this is high-level stuff when it comes to realizing a good claim versus a bad claim. So let's say you have your hearing, and then you have to make the choice. I'm going to go to appeals counsel. It's going to take me 12 months, but my date last insured, boop, is right in the middle at 6 months. If you go ahead and file that appeal into appeals counsel, and you ultimately get a denial, the only shot you have to reattach to your SSDI benefits is to go back to work. A lot of people don't realize that, because you've now waited 12 months, you're 6 months past your DLI, and you got a denial 6 months after your date last insured, which means that your claim to benefits, you can't claim going back in time, basically beyond essentially, that moment in time when you got that denial. You can't go back in time and claim, I became disabled, before that. So your only option is to go back to work or potentially take it to federal district court. Those are your only two options. You could go back to work, get some more quarters of coverage, or you could go ahead and basically, take it to federal district court. When you take a claim to federal district court, you can go ahead and file a new initial filing as well, which is really, really super duper. Okay, so let's talk about that real quick. When it comes down to making hard choices about a denial at the ALJ level, here are the main things that tend to be the problems that people face at the ALJ hearing level. Number one that I see is they put dumb stuff on their initial forms, which comes back to haunt them in the administrative law judge brief, and also with the vocational expert that's looking at the jobs you put down, and everybody blows their jobs up. I was the senior vice president of cookie cutting at and handling payroll and substitutions of employees, hiring and firing, yada, yada, yada. And remember, the only time you want to have very skilled work that you were doing is if you're over 60. Because then if you're over 60 years old, the bottom line is that they're not going to consider other jobs in the national economy. They're only going to consider, can you do the past jobs that you did? So only when you're over 60 do you want them to have super highly skilled jobs as claimants, right? So when you're over 60 and you're claiming your alleged onset date was past 60, right? Because if you claim your alleged onset date was before 60, that's a problem. That's a problem, because that means they have to go back and consider you during the 55 to 59 year era, because that brings back element 5 of the 5 elements that make up disability law. And element 5 is, can you do other types of work in the national economy? We call it RTSW, relevant, transferable, skilled work and unskilled work. But we don't want element 5. We want just to have to deal with element 4 for an older person that's over 60. So if you set the alleged onset date to basically the day they turn 60, or in SSA law, we always do it the day before the birthday, then what it means is that you are only considering element 1, 2, 3, and 4. Element 4 is, can they do their past relevant work? And if the person can't do their past relevant work, whoa, pretty cool, pretty good. That means that if they had, super high skilled labor, SVP 7, SVPs 8, SVP 9s, then that means, wow, okay, cool. They're not going to be able to do those jobs because they required all this skill and all this extra work and all this extra movement, yada, yada, yada. They can't focus if they're in pain all the time. All right, so let's go through that real quick. Now, if you're under 60 years old, right, and you're trying to get disability benefits, you don't want your jobs that you did in the past to have all these extra skills, all these high SVP numbers, all these different things, because then they have transferable skills from those prior jobs that you used to utilize and do over the past 15 years to transfer the other types of jobs in the national economy that could have other skills. It opens up the opportunity for more jobs in the DOT be brought forward. So a lot of you guys that have gone through hearings before, you'll hear like this basic thing, which is, okay, the vocational expert will come out and the judge will say, okay, only occasional reaching in all directions, can't do fast-paced environment, can't be on a line, can't be on a conveyor, yada, 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 so on and so forth. And then the judge will say, are there any jobs in the national economy that the person could do? And then the vocational expert goes click, 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 and they look around. Okay, I see these jobs. And usually they'll come up with 3 jobs. 3 jobs is what they always tend to come up with. However, here's another trial tactic. If they come up with less jobs, then we look into are these jobs representative? Is the list exhaustive? Because if the judge is finding, well, wait a minute, there's only like 1 or 2 jobs in the national economy, based upon the hypothetical question, like the limitations that this claimant would have that the judge is proffering. So the judge is saying, if the claimant has these limitations, what jobs are out there that they could do? And if the vocational expert comes back and says, well, there's this job and there's this job. Well, the judge knows that. Vocational experts are always supposed to give 3 jobs. And if the vocational expert doesn't give 3 jobs, then it's a bell for the judge to go, hey, wait a minute. Is this list, are there more? Where are there more jobs? Are there only 2 jobs in the big DOT, the Dictionary of Occupational Titles? Right? And if you don't know what the Dictionary of Occupational Titles is, it's the book of jobs. It's old, it's dusty, it's digital. But the bottom line is it's the book of jobs. They have everything in it. They have rocket scientists, they have strippers, everything's in there. It's pretty cool. You ever want to look up what you are, you can. You can actually just search Dictionary of Occupational Titles and type in what type of jobs you've done before. Let me answer this real quick question. Thank you for sharing your knowledge. Thank you, good sir. Sarah Diaz, how about if your employer approved your disability, but SS denied it? I am 59 and my hearing with the ALJ is October 30th, so around the corner. I will be 60 in February. All right, so look, here's the deal. If your medical evidence is good, okay, hold on, I see lost reception. Can you guys still see me? So if your medical documentation is good, then you should roll the dice at the 59 to 59 category, right? That's the 55 years to 59 category. And here's why. Here's what happens. At 55 to 59, you fall into the griddings for a 55-year-old to 59 and a day before 60, which are very favorable when they look at the light and sedentary potential jobs that they could give you. Now, I want to explain here. They split up jobs into 4, no, it's actually more than that, a couple of categories, right? You've got light jobs. Sorry, you've got sedentary jobs, sitting jobs, light jobs. You're walking 6 out of 8 hours, you're sitting 2 out of 8 hours. Medium jobs, you're lifting more. Heavy jobs, you're lifting even more. Very heavy jobs, you're going to break your back. These are the categories that jobs fit into. It's super duper important. Good, you guys can see me. Okay, cool. So Sarah, here's the thing. You're looking at that particular age group, the potential of light or sedentary based jobs. And what you're looking to do is grid out. So what I want you to do is I want you to go look at what are called the grids or the griddings, but usually they post them on websites as the grids. And the way the grids work is they're set up in 5-year intervals from 45 years up, 45 to 50, 50 to 55, 55 to 60, 60 to 65, etc. They're set up in 5-year intervals. And then the older you get, the less education you have, the less work experience you have, the more likely you'll be found disabled. Okay, so the whole point is here, you should roll the dice and see if you can get what's called a a grid out. Now, here's the thing too. Don't get greedy with your alleged onset date. Some of you guys are like, well, I applied 3 years ago, and if I take it back 17 months for my SSDI maximum, it puts me into the 54-year-old category. Don't do that. Set that puppy at 55 and ride. Roll the dice for the 55 to 59 in the day before 60 category and ride that puppy. Okay, that's what you want to do, because otherwise you're rolling the dice too much. Okay, if you're stuck in the 50 to 55 or 54 in a day before 55 category, totally understandable. That's totally fine. But if you're already in the 55 and heading towards 59, don't get greedy. Stay within the 55 to 59 category. The judges are much more likely to approve them. Okay, so what else? Totally forgot what we were talking about before with the strategy. Sweetie, come on. So what this means is that, okay, so when it comes down to strategy, right? Oh, God, what are we talking about? I got a barking little sweetie chubby dog. When it comes down to strategy related to this stuff, yeah, you're probably going to have to just let her out and stay out there, because otherwise she's going to bark a bunch. So, guys, here's the deal. And Shadow's totally good. He's passed out from having too many treats, which is kind of his deal. So, all right, now, with that said, I want to go back to what we were talking about, but I can't remember because I'm so tired. I've been writing so many briefs and my eyes are already gone. But here, I'm going to put this out one more time. And then what we're going to do is we're going to go ahead. If nobody wants to call in, I'm going to probably end it around 45 minutes, because I have to work on tax stuff, I have to work on title stuff, and I have to work on a brief, and I have to mail out about 12 things, which takes about an hour and a half at the USPS. All right, guys. So another trial. All right. So we were talking about, and here's the big thing, the COVID situation. Okay. The COVID situation. COVID-19 means all these SSA people are basically stuck at home. You got 800 phone number SSA people stuck at home. A lot of the local field office people are stuck at home. You still have managers. They're only doing certain basic things when it comes to letting people in to go ahead and assist them. These judges, they're not going to bring them back. They're not going to bring them back for at least another year. I'm telling you, and here's why. Because let's say they release a vaccine. Okay, let's say that it's going to take 6 months to go ahead and get a lot of people in the vaccine. That doesn't mean all these homeless people and these low-income people that are applying for disability benefits are going to have this vaccine. Sure, they could go to a program, but not all of them can get to a program. They don't have transportation. They don't have a car. They don't have a bike. They don't have any of that stuff. So the bottom line is they're going to be very fearful of bringing these judges back, and here's why. They cannot afford, I'm going to say it again, they cannot afford to lose these judges where they're gone for a month. Okay, when they get sick, it's a big deal. Lots of cases have to be moved. It's a whole harangue, and that's because these judges are really indispensable. There's not enough of them, and the bottom line is they don't have enough of them. Now, here's the thing that the SSA is looking at. The SSA is looking at, howdy, Sherry. Sure, if you want to call in, I'll run questions with you. Same with Sarah. If you want to call in, I'll run questions with you. If not, I'm going to go to, well, I actually have to go do the USPS. So here's the deal. When it comes to these judges, let's see, Florida Chameleon. I first applied in 2016, denied, then appealed, denied. Waited till I turned 50 this year, then was approved. Excellent. So utilize the gridding option, and that's great. And there's 4 main ways to be found disabled. There's CALs, compassion allowance listings. There's listings, element 3 of the 5 elements. There's griddings. That's where the older you are, the less of the skilled work, the less of the education, etc., the more likely you to be found disabled. And then, of course, there's vocational allowance. That's where the vocational expert is saying that, hey, there's no jobs in the national economy that which this person could do. Ergo, it's a work preclusive scenario. They call it work preclusive because there's no jobs in the DOT that person could do based upon the hypothetical that the judge gives them. Is it better if my lawyer asks me questions at my hearing, or if the judge asks me? My hearing is in October 21st. Okay, we've got a call coming in, but then I'll answer that. Hi, this is Attorney Walter Knott, Disability Resolution. We are live. Good sir, go ahead and use a fake name for the record.
That'd be Mark.
Mark, excellent. Help me out here real quick. Would you like me to run questions with you, or do you have a specific question?
I had a specific question. I went to one of their doctor appointments they sent me to for mental health.
Sure.
And it's I've been, it's about my second time to mental health than initially physically. And I'm just curious about her prognosis. I wanted to kind of read it off to you and see what you thought about it.
Sure. Okay. Sure.
Okay.
Yeah. Go ahead.
What it says here is, Mr. So-and-so is a single Caucasian male, 47 years of age, who appears to meet criteria for antisocial personality disorder, an unspecified trauma and stressor-related disorder, given reported symptoms and clinical observations. The overall presentation appeared valid and consistent with some of the reported conditions. The mental health symptoms based on report and clinical observations appear to be moderately impacting activities of daily living, vocational performance, and interpersonal interactions. Current prognosis for Mr. So-and-so is guarded. In regards to financial management, Mr. So-and-so is recommended to manage benefits and final decisions.
Okay. Any additional information? Any information about you able to handle bills? Any information about you interacting with other people? Anything like that?
No.
Okay.
It just ends rather short like that.
Okay. Okay. So now let's do this again. Read it again, and then as you're reading it, I'm going to jump in and explain portions of it.
Okay. Where should I start at?
Very beginning. Very beginning.
All right. Mr. So-and-so is a single Caucasian male, 47 years of age, appears to meet criteria for antisocial personality disorder and unspecified trauma stressor-related disorder. There are reported symptoms and clinical observations.
All right. So
overall presentation.
yeah, go ahead. Go ahead. Get a little bit more into it, and then I'll jump in.
The overall presentation appeared valid and consistent with some of the reported conditions. The mental health symptoms based on report and clinical observations appear to be moderately impacted activities of daily living, vocational performance, and interpersonal interactions. Current prognosis for Mr. So-and-so is guarded. In regards to financial management, Mr. So-and-so is recommended to manage benefits financial decisions.
Okay. All right. So, all right. Now I'm going to walk you through this like I would walk an intern through it. Good sir, what is the impairment that we're looking at?
All right, say that again.
Well, good sir, what is the impairment that we're looking at? And I'll give you a hint: antisocial. So you tell me.
Antisocial
Personality. Yep.
ASPD.
Okay. Perfect. What is the listing specific for that particular impairment for an adult?
I'm not sure.
It is 12.08. Are you in front of a computer right now?
Yes.
Okay, do me a favor. I want you to go ahead and Google 12.08 personality and impulse control disorders.
So was it 12.08?
So you're going to look up Google SSA disability listing 12.08. It'll probably come up with the 12.0s in general, which are the mental disorders. And then from there, basically, we'll go ahead and scroll down on that page to 12.08. Let me know when you get there.
The chronic mental disorder?
Yeah, you're in mental disorders, and you're going to scroll down to 12.08, personality and impulse control disorders. So, guys, just so you know what we're doing, we're going to actually walk this through like I would walk through a new intern that has a legal background, but I'm going to go ahead and make it a little bit simpler than that, because if the intern didn't know which listing it was, we would beat them horribly. We would put them over the board. But yeah, good sir. Go ahead and go to your 12.0s and then scroll down to 12.08. If you're not able to find it, I'll take the URL and I'll post it right in the comments section.
Yeah, I'm having a slight hard time following that because I actually have a TBI.
Okay. All right. So are you able to see the chat? Gotcha. Are you able to see the chat area, like where people are chatting? All right. Grab that link that's there. While you're grabbing that link, I'm going to answer this question. Cheyenne just pointed something out here. Maybe not a question with COVID. Let's see. Is it better if my lawyer asks me questions at my hearing or if the judge asks me? My hearing is October 21st. Okay, so just my opinion. Here's the basic bottom line with that. It's better if your attorney asks you questions for smoothness and your prior preparation, because you know the attorney's voice, you know what types of questions and how they phrase them, so you're more comfortable, and your attorney can go ahead and manipulate the questions, what they ask you, to be in your favor. They can phrase things in your favor. And a lot of you guys don't realize how big of a deal the manipulation of the sentence is, but it's huge. There are times when I come out with a sentence that completely wiggles my way around what the judge, would normally be asking about, and it just gets around that thing, and then boom, we're on to the next subject, and we're out of that bad territory. Attorneys are great at rephrasing things to be in a positive way for you. That's why a lot of them are in politics. That's why a lot of them are doing the court stuff where they're saying, okay, well, what if we look at it this way? Yada, yada. That we're great at that, and that's because we tend to be wordsmiths. We have a pretty high education, pretty high intellect, and we have the capacity to go ahead and maneuver words as such to make it work for our best benefit, or in this case, our clients. Now, here's another thing, though. It is better if the judge will go ahead and ask you questions, because the judge gets instant satisfaction from you answering them. The judge is more likely to believe the answers of you giving the judge, being that if the judge asks you a tough question, you give a good answer that doesn't involve the negativity that the judge was looking for. The judge is more likely to have sympathy for you and more belief in the validity of your statements than if your attorney asked them, because the judge knows the good attorneys, and the judges know which are the crap attorneys and the good attorneys, but the judge knows with the good attorneys prep their claimants. So the good judges know if they want to ask tough questions, they're going to wait until that attorney's done, hold on to those tough questions, and then ask them, because they know that those attorneys will pre-prep them heavily. All right, so good sir, let me ask you this. Have you been able to find the 12.08?
Yeah, I did.
All right, I want you to do me a favor. I want you to read for me 12.08. We got to have element A and element B. Good sir, read for me element A.
Okay. Medical documentation of a pervasive pattern of one or more of the following: distrust and suspiciousness of others, detachment from social relationships, disregard for any violation of the rights of others, instability of interpersonal relationships, excessive emotionality and attention seeking, feelings of inadequacy, excessive need to be taken care of, preoccupation with perfectionism and orderliness, reoccurring impulsive aggressive behavioral outbursts.
Okay.
That's A.
That's A. So that's A, man. Those are pretty darn specific, right? Distrust and suspiciousness of others. So now let me ask you this. When you were there with the Social Security doctor, did you bring up any of these?
Actually on my own, as we discuss things I deal with on a day-to-day basis. Some of these are familiar, yes.
Okay. The doctor ultimately gave you a medical severity notation of moderate. Is that correct?
Yes.
Is moderate severe?
No, it's just below it.
Correct. You have trace, mild, moderate, severe, extreme. What do you need to be found disabled?
One thing severe, I believe.
Usually severe. However, and we're going to make a good point of this, okay? This is very important for the 12.08 base listing. Here, let me put this in the, we're on 12.08, guys. This is specific to the impairment. Usually just severe. But when they modified the rules over the past couple of years, they started to snooker in for some of the 12.0 mental impairments, the extreme limitation requirement. Good sir, can you read for me B?
Okay, B. Extreme limitation of one or marked limitation of two of the following areas of mental functioning: understand, remember, or apply information, interact with others, concentrate, persist, or maintain pace, and adapt or manage oneself.
What's the most important part of all that? It's a word.
Me, it would be the interaction part.
Okay. Now, when it says B, extreme limitations of 1 or marked limitation of 2, what does that mean?
I don't know myself off the top of my head.
Okay, so what they're looking at here is this. You have a long ladder, which is extreme. That gets you all the way there to the ledge that you need to get to. And then you have 2 short ladders, which you got to combine and put together to get you there, to that same ledge.
Right.
Extreme limitation is that long ladder. It gets you right to where you need to be, right? And most people sit back, they're like, I thought I only had to have a severe impairment. Not for mental impairments anymore. Sometimes you need to have an extreme limitation. However, they give you a way out. The way out to have severe is to have or marked limitations of 2. And marked, what does marked mean? It's the one less than extreme. It's right below extreme. What's right below extreme?
Mild.
No. So it's trace, mild, moderate, severe, and extreme. What's right below extreme?
Severe.
Perfect. So we got to have one of these in extremely bad fashion, or 2 of these in severe fashion, right? So 1 is extreme, like you can't even function. And let me give you kind of what that means. It means that, trace, we don't really give a damn about. Mild, you can pretty much do it without that much of a problem. Moderate, it's starting to become an issue where you're limited in the amount of time that you can actually do it. Severe, there's even more time during the day in which you can't do that function, right? Understand, remember, apply information, interact with others, concentrate, persist, or maintain pace, adapt or manage oneself. Extreme is like you can't even do it. You just can't do it. You just cannot do it. It's just you can't understand. You're literally drooling. You're all over the place. Interact with others. That's fine until you shoot them. Concentrate, persist, or maintain pace. You're not going to be able to do that because the medications you take make you see monsters. So the point is, when it's extreme, you can't even do it. When in the 12.0s, that means we're talking sanatorium stuff. Okay, so you got to have 1 sanatorium level extreme in one of those categories, or 2 severes. All right, good sir. I want you to read A again, but just the A part where, before it gets to the 1 through 9. And then I want you to say, and B, and then read me the B part without 1 and 4.
Okay. There's A, distrust and suspiciousness of others, detachment from social relationships, disregard for and violation of the rights of others, instability of interpersonal relationships, excessive emotionality and attention seeking, feelings of inadequacy, excessive need to be taken care of, preoccupation with perfectionism and orderliness, recurrent impulsive aggressive behavioral outbursts, and understand, remember, or apply information, interact with others, concentrate, persist, or maintain pace, adapt or manage oneself.
Okay. So now I want you to tell me, which of those in the A category do you feel that you have?
Number 1, number 2, number 3, number 4. 5 out of 9. I can identify with.
Okay, 5 out of 9 in the A area. What about B?
And B, that's 3 of the 4.
Mm-hmm. Okay. Now, let me ask you this. If you knew that statute ahead of time, do you feel that you would have been more able to accurately portray those impairments or the result of those impairments, which is what these are, the resulting actions of an impairment? Do you feel that you would have been able to go ahead and express those to the SSA DD or SSA medical expert as part of the consultative examination?
Yeah, I do.
Okay, cool. Now let me ask you this. As you look at it, every time you read it, do you see more of them in you? Do you see that you are more of those things on those lists?
Yeah, absolutely.
Okay, cool. Now let me ask you this. If you were to go ahead and read these off to the DDS reps, to the medical expert at the consultative examination appointment, if you were to just read those off, what would that cause the medical expert to feel? Would the medical expert feel like you just read the statute and you were just going ahead and reading it off to them?
Yes, I believe so.
So what would be the best way to describe these things without it keying them off that you know exactly what they're looking for?
I would say just like in my initial when I filled out that paperwork and they wanted to know what I did through like the whole entire timetable of the day.
3373.
I believe just going over that.
Yeah.
I could most likely touch upon almost all of these.
All right, well, let's play a little game. We're going to play. All right, so go back to A. Which one's in A? Give me the numbers. Do you feel that you meet?
Number 1, distrust and suspiciousness of others. Number 2, detachment from social relationships. Number 3, disregard for and violation of the rights of others. Now that's only a half and half. Is that okay though?
So here we are. We're at 1, 2, and 3. We still got 4 through 9. Every time we go through this, you're going to see more of these in yourself. I want you to now take 1, 2, and 3 and put them in your own words and describe them without using those terms.
Without using those actual words?
Right. So I'm going to say to you, the statute says distrust and suspiciousness of others. You would say it as...
I have a hard time meeting friends because I'm very non-trusting.
Okay, but wouldn't that fall into the instability of interpersonal relationships in number 4?
Yes. I mean, as far as
and it's
friends
a trick.
and co-workers, anyone I interact with.
Mm-hmm. It's a trick because some of these combine, and that's the problem with it. The problem is that some of these are the result of other ones. You have instability of interpersonal relationships because you have number 6, feelings of inadequacy. Number 1, distrust and suspiciousness of others. Number 4 is really a conclusion of some of the other ones that are on this list. So always, another trial tactic, always look for those in the actual statute that are the conclusion of some of the other ones. So let's go back to number 4. The conclusion statement is instability of interpersonal relationships. That is a conclusion. What are, in your opinion, some of the other ones, 1 through 9, excluding 4, because that's 4, that's our conclusion sentence. What are some of the other ones? We know number 1 is one of the things that causes number 4, distrust and suspiciousness of others. We know that number 6 is feelings of inadequacy, also causes number 4. What other ones cause number 4?
I would say the excessive need to be taken care of.
Mm-hmm.
And
number 7.
The number 9, recurrent, impulsive, aggressive behavioral outbursts.
Okay.
The number 8, I would disagree with the perfectionism, but I totally identify with the orderliness.
Mm-hmm.
Because unfortunately, I don't know why, but I stopped brushing my teeth like 3 years ago, and I felt in the shower but once or twice a month.
Mm-hmm.
That causes trouble. It's not the program, sorry.
Mm-hmm. All right, so let's go through this real quick. Number 4 was a conclusion statement. Can you point out to me another conclusion-based statement in 12.08 listing, subsection A, that is a conclusion statement that is caused by the other 1 through 9?
Number 7 would be a conclusion statement. Excessive need to be taken care of.
Well, that would be something that, excessive need to be taken care of is actually something that would cause something like, a number 4 or a number 2. But you could look at number 7 potentially with that. That could go either way. But number 2, I think, is a good one. Detachment from social relationships. right? That is the conclusion of issues that you may have: feelings of inadequacy, excessive emotional and attention seeking, instability, and that disregard for and violation of the rights of others. That will cause detachment from social relationships. So my point here is this: we're in 12.0A subsection A, talking about mental impairments for personality and impulse control disorders. And what we're going through are the 2 paragraphs provided. A is all about, do you have a pervasive pattern of 1 through 9? B, which you have to have, it's an and element, not an or, it's an and element. That means what we're looking at is we got to have 1 extreme or 2 marked, which just means 2 severe ones, right? 2 of those severely. So here's the bottom line. Now, I want you to tell me this. If your CE doctor stated, and I want you to go back and read it, read me the part that's 2 sentences before and then including the moderate sentence.
Okay. The overall presentation appeared valid and consistent with some of the reported conditions.
So you weren't lying.
Oh, I guess, yeah, that's what that means.
Yeah, you weren't
mental
lying.
Health symptoms
Yep, go ahead.
based on report. I'm sorry, go ahead.
Go ahead, though. That's good.
The mental health symptoms based on report and clinical observations appears to be moderately impacting activity of daily living,
Okay.
performance, personal interactions.
Read that one again. Read it nice and slowly.
The mental health symptoms based on report and clinical observations appear to be moderately impacting activities of daily living, vocational performance, and interpersonal interactions.
Okay, cool. So what they're saying is there, the record and what the doctor is seeing right now, that's what they're saying. The record and what the person is seeing right now looks like somebody who is moderately impaired. And now give me those categories again.
Daily living, vocational performance, and interpersonal interactions.
Okay, so getting through the day with home stuff, working, and interacting with others, right?
Yes.
Okay. When we go to B, can you tell me which one is interacting with others?
Number 2.
Can you tell me which is home stuff? It's all of them. Can you tell me which is work stuff?
Work stuff would be...
It would be all of them, all in B.
Number 3, concentrate, persist, or maintain pace.
It would actually be all of them.
And number 1, understand, remember, or apply information.
Well, don't you have to interact with others at work?
Yes, you do.
And number 4, adapt and manage oneself when you're at work?
Yeah, I would think so.
So it's all of them. What did they say? Did they say that you had severe limitations? Did they say that you had extreme limitations with these, or did they say you had moderate limitations?
They said they're moderate with these. My first time I went for it, I went for my TBI because I had enough work credits. I just wanted to. I had no insurance. I wanted to, get health insurance and get back in the workplace. But my cognitive skills tests that they gave me said I had only memory of 24 hours at a time. And yet they still turned me down. And that was back in 2012. And I finally go before the ALJ on December 4th.
Okay. Do you feel with that consultative...
This is the last doctor they sent me to back on the 12th of September.
So that's recent. Okay. All right. Do you feel that medical report from that doctor helped you?
Yeah, I do.
Why?
Because it's some of it is accurate. It's a little diminishing opinion, but I feel like some of it's accurate.
What was the conclusion of the doctor? Did the doctor conclude that you had extreme or severe impairments?
It just says moderate, and that the prognosis is guarded. And what does that mean, guarded?
There's different things for basically guarded, fair, so on and so forth. And all these have a legal terminology that it falls into like a rubric, kind of like, the mild, moderate, severe. And it depends on which impairment they're talking about, but it talks about basically your limitations and how bad they are and how you approach them. And so in this case, it's not what you need. It's how you, as a disabled person, present yourself, and your abilities to go ahead and do things. So if you are fair or guarded, they represent these legal terms that limit your ability to do vocational tasks. But I could have done a better job explaining that, but I'm just tired. But the bottom line is this. In that whole thing, at the very end of it, did the judge, I am tired, did the judge or did the medical expert say that you had a severe or extreme impairment, or did they only say that you had a moderate impairment?
They only said moderate.
If you only have a moderate impairment, now what is your most severe impairment that you would say out of all of them?
Well, it's the combined for me.
Okay, but what are the top two then?
TBI.
Okay.
It's my TBI diagnosis with this doctor's diagnosis.
Okay, so you got a traumatic brain injury, and then you got a personality disorder. Okay.
Yes.
All right. If your personality disorder is moderate, is that something that is going to win you disability benefits?
I was under the impression that for combined, they had altogether equal severe.
Well, you have that option. You can have many moderates equate to, severe functional limitation. You could have that, but that's not this situation. It's not. In this situation, you needed that doctor to come back and say that you had at least severe. And you needed basically and what are they saying about your TBI, your traumatic brain injury?
They're just saying that I could do day labor.
So you could do day labor as somebody with a traumatic brain injury. Now, how does your TBI, how does it limit your ability to do work?
It affects just my short-term memory. I'm just supervised basically, or just re-given instructions.
Okay. So if you were able to work at a place where a supervisor was nearby, you would be able to do it.
More than likely.
Well, that sucks because that's exactly what the judge is going to say, and you're not going to be found disabled.
As long as it was a person I can get along with.
Okay, now we're starting to finesse it. Tell me more.
Because unfortunately, I've told them, like my lawyer, I've actually never met my lawyer. I'm going to meet them for my first time on November 3rd.
Mm-hmm.
So they're going to speak to me, and they said they're going to go over everything with me, like you were saying.
Mm-hmm.
And that scares me that it's only going to be done this one time.
That would scare me
right
too.
Before the actual ALJ.
Yeah.
I thought maybe I would have met them sooner,
Yeah. Look,
I have unfortunately, I have an 8-page criminal record,
mm-hmm.
and none of them are actually crimes. What they are is interactions. And if I interact with authority figures, I tend to get violent depending on their overall character. And so I have a lot of assaults and batteries against law enforcement. And it all comes from my PTSD. Now, thankfully, no one knows who I am, so I could share that with you.
Yeah.
My PTSD comes from being raped.
Okay.
And so I lose control of myself quite easily depending on who I interact with.
How long ago?
Because of that.
How long ago?
2012.
Okay.
Happened in 2012.
When did you stop working?
I stopped working 2015.
All right, so your main claim is actually PTSD. It's not a 12.08 personality. All right, all right. Would you be offended if I told you your claim wasn't built right?
No, I wouldn't be offended. I mean, I've been doing all on my own. I just now got the lawyer as of 2 months ago.
All right.
Did be my third time.
Did you go ahead and get your did you get your crim records? Did you get the police reports that show you have a consistent inability to go ahead and control yourself with authority figures?
I have the actual the record which I got from the courts, and I mentioned to the aide who I spoke with a few weeks back, who gave me the date of when I'm going to speak to my lawyer on April 3rd or on November 3rd. But was it the second? Yeah, I think it was the second.
When you
I bring it up to my lawyer then, so they can see that.
Okay.
And see, what she says.
Shadow.
Copies of that.
So let me ask you this: when it comes down to, all right, so let's go through this real quick. So 2012 is when the trauma happened. Where now is that when the TBI occurred as well?
No, the TBI came from what it is I've owned 16 motorcycles. I used to race motorcycles.
Okay.
And I've crashed 12 of them over a period of 17 years.
Okay. So
like a boxer or a football player, I've been taking impacts to my skull for a very long period of time. And, I unfortunately decided to run from the cops one day. Mm-hmm. And when I ran from the cops and crashed my motorcycle, they decided to give me a beating.
Gotcha.
And so when they tried to enter me into the county jail was giving me medical tests, and they refused to accept me because they said there was something wrong with me.
Okay.
And when they sent me to the hospital, that's when they found the TBI doing scans.
I'm assuming you had some sort of recourse against the officers who did that?
I intended to, but they kept coming to my house and making threats to us. So we moved away and we let it be.
Shut up!
Which was a big mistake.
Shut up! Oh, hold on, good sir.
But we were scared, and so we didn't want to. My
Shut up.
Girlfriend is a firefighter, and she also kind of had an issue with crossing the line because she had a lot of cop friends and stuff like that. So we just moved away and sucked it up.
Gotcha. Okay. All right. So what we got here is a situation where you have PTSD from getting beaten, PTSD from a rape. You have PTSD that now. When do you have panic attacks?
Yes, I do.
All right. So we got panic attacks in there. You have anxiety, I'm sure.
Yes.
And you're depressed about what happened in the past.
I'm always depressed.
How long have you not been working?
I haven't been working since 2015.
Are you currently taking medications? I would assume you're taking medications, right?
No, because I don't have my own doctors. We couldn't. We tried all kinds of community, organizations to get me help and so forth, but because it's a TBI, there is no actual help that's free for TBI, and then all kinds of other things. I fell through all the cracks for everything that could possibly help us. Plus, the area I live in, fortunately, it's just outside of Polk County, Highlands County,
okay.
Florida.
Yeah, I got you. Okay. All right. Let me ask you this. All right.
I've never had my own doctors.
So basically, we got a very light medical record. So basically, we have a light medical record. We have not properly diagnosed impairments. We have an attorney that's going to run questions with you once. What do you feel your top 5 impairments are?
My number 1 is PTSD with the TBI, and then last, my mental health.
Last, your mental health. Okay. All right. So what does your mental health mean? What does that equate to?
I'm not exactly sure what with that question.
Well, how about anxiety, depression, panic attacks, PTSD, personality disorder?
Yes.
Okay.
All of the above.
So you went to an SSA doctor, and they only reviewed you for what?
The first time was for cognitive skills. The second time was for all my physical ailments, which is nothing major at all, just a torn meniscus disc. And my mental health, the very first time, which was, they said that doctor was at Osceola Hospital at the time. That doctor's prognosis said that I had PTSD and unspecified bipolar disorder. And then as of recently, they asked me to go see this one, and that's when I got this one I read off to you.
Okay,
So
gotcha.
I've been to 4 doctors total.
Okay. All right. Okay. All right. So here's kind of the bottom line with this. You need more claim building when it comes to your mental impairments. You need another CE, potentially post-hearing, and you're going to need basically a better workup to understand and utilize in your own words those things that you saw on that 12.08. You're going to need 12.04. You're going to need 12.06. And you're going to need 12.15. So let's go through it again. You have 12.15. That's your PTSD. 12.08. That's your personality. 12.06. That's your anxiety. And 12.04. That's your depression.
04?
Yeah. Go read those, go learn those, go use those. Those are super duper extremely important, because those are going to equate to what you need to know to be able to successfully navigate this thing. And then my recommendation is, when's your hearing again?
It's on December 4th.
December 4th. All right. Next week, call in. We're going to run questions. That way you'll get a little bit farther down the line. In the meantime, go watch the top 50 ALJ trick questions. Go watch the top 200 hearing questions that you're likely to see at your disability hearing. So top 50 ALJ trick questions and top 200 disability hearing questions.
Awesome. Will do.
Perfect. All righty. So guys, I'm going to actually, good sir, I'm going to catch you later, and I'm going to end the video here at this point, because I only intended to do it.
Thank you very much. You have a good night.
You as well, good sir. Bye-bye. So guys, I'm going to go ahead and end the video here, because I'm rubbing my doggies right now, and I'm super duper tired. I got to work on taxes, do some mailing stuff, and it's probably going to take me till about 1 or 2 a.m. My recommendation is, if you guys want to go ahead and ask me questions or any of that stuff, catch up with me next week on Thursday, Eastern Standard Time, 8 to 10 p.m. The way it works is I go live. You call that 407-279-1754 phone number, and then I will go ahead and answer it if I'm not already on the phone with somebody, and we will go from there. All right, I'll catch you a little bit later. Have an absolutely wonderful night, and thanks so much, guys. All right, bye-bye.